Hi, everyone. Thanks for joining us tonight. We are going to be talking about the asylum rule. And recently, the Biden administration published a new rule proposing to make asylum processing more efficient and fast for some asylum seekers. So, we are going to discuss that tonight. I am Lindsay Wilkes with the Light Legal Immigration Law Firm. We are an immigration firm in Washington, D.C., serving clients all across the U.S. and the world. And we represent a lot of asylum seekers. And I also have with me tonight here Parisa from Asylum Works, who we partner with a lot. And I'm going to let Parisa introduce herself as well.
Hi, everyone. My name is Parisa, and I'm the program manager at Asylum Works for legal outreach. And we partner with Alight Legal a lot of times where we make referrals to them based on their advocacy needs, whether it's asylum or some other form of benefit. So I'm here to basically discuss the impact of these new rules on our current clients.
Thank you, Parisa. And so for this new rule, we all received a lot of emails as soon as it was announced and as soon as it went live that there are new things coming down that could hopefully make asylum applications move more quickly through the asylum office and immigration court. The good news is that the new rule does propose to do that. The bad news is that it is only for certain asylum seekers. And so we hope to clarify tonight what that means in terms of the asylum seekers that we serve, as well as what the old rule was, and look at this new rule. So first, the new process for asylum applicants only impacts a very small, I don't want to say small because it's going to be hundreds of thousands of asylum applicants, but it only affects a particular sect of asylum applicants. And those are the applicants for asylum who come to the border. So when someone tries to enter through one of our borders and is caught by Customs and Border Patrol or presents themselves to Customs and Border Patrol and expresses a fear of harm in their home country, then this starts the process for what is called credible fear. And instead of being put into instead of being deported immediately, that asylum seeker is supposed to be given the opportunity to have a credible fear interview for our government to determine if they do have a credible fear of return to their home country and if they should be permitted to seek asylum in the U.S. So it's only these asylum seekers, there's only going to be these asylum seekers that are impacted by the new process and procedures in this rule. At least that they're the only ones that the rule applies to. We'll talk about the residual effects and how that may look for or how it may impact other asylum seekers, even though this rule isn't meant to change your process for seeking asylum. So for the current rule, once someone passes this credible fear interview, then they are put into removal proceedings before the immigration judge. And then you have to file an asylum application before the immigration judge, and the immigration judge determines whether or not you are eligible for asylum. So now this new rule, it was published May 31st, it will go into effect May 31st, 2022. It's a very large rule, and the government is expecting to roll it out in phases. Not every single thing will happen at one time because it is so large. So they do expect to have a staggered implementation. And the rules, again, only apply to people who are entering the U.S. in the future after this rule has gone into effect. And it does not impact people who are here now, or the new rules don't change the process for the people who are here now. And it's also not going to apply to unaccompanied minors who enter, and it will also not apply to people who are paroled into the U.S. without being put into expedited removal proceedings. So once again, the new rule only applies to people who are being put into expedited removal proceedings, and then it affects the credible fear interview process and the next stages. So where the main changes come is really what happens after the credible fear interview. After the credible fear interview, the new rule is going to require that the asylum office conduct an interview for the applicant. So no longer will the person whose credible fear interview is approved immediately go to the immigration court. Now the asylum office, who also adjudicates regular affirmative asylum interviews, will now conduct a full merits interview for the person in expedited removal and determine whether or not that person is eligible for asylum. Now, the timeline is very short for these asylum seekers. Once the credible fear interview has been completed, then the asylum office has a very short time frame for conducting the asylum merits interview for these applicants. They cannot interview the person for their merits interview earlier than 21 days after the CFI, but no more than 45 days after that either. Now, USCIS will decide whether or not to grant asylum. They also, the asylum officers, which asylum officers have not been able to consider this before, will be able to consider whether that applicant is eligible for what we call withholding of removal or cancellation of removal. Again, only for folks in expedited removal, but this will be a brand new type of relief for asylum officers to consider, whereas before this was only possible by the immigration judge. Also, a big change is that for these asylum seekers, the credible fear interview itself will be considered your application for asylum. You're not going to have to file a separate I-589 application for asylum if you pass your credible fear interview. And therefore, once you pass your credible fear interview, then the asylum clock will start for you. So to sum up what the possible results could be after the credible fear interview, one, if you're granted asylum by the asylum officer, now you have asylum and you can move forward as an asylee in the United States. If the asylum officer does not grant asylum, then your case will have to be referred to the immigration judge, and you will have another opportunity to present your case before the judge and hopefully win asylum. However, where the rule makes some major changes with the immigration court and these asylum applicants is, again, we have very strict time procedures in place now for how quickly the immigration court has to review these applications. They only have 30 days to set the master calendar hearing. After that, you have 30 days for basically a hearing between the different parties to discuss what the options are and what they're going to do. And then the final hearing has to be set. So within 2 to 4 months of being referred, you should have your final merits hearing. And this is much, much, much faster than almost anything we've had in recent history for asylum seekers. So Parisa, I'm gonna let you now take it over and discuss how this may impact our primary client base, since both your organization and our firm, we serve a lot of affirmative asylum seekers or asylum seekers who were never in the expedited removal process.
Thank you, Lindsay. Okay, so I just wanted to reiterate what Lindsay has said. This is basically for asylum seekers who have expedited removal proceedings at the border and who arrive without a visa to have their credible fear interview. And this is prospective clients. So anybody in the pipeline right now, this rule is not going to impact your case. However, it might impact the timeline of your case. Now, as always, we can't predict things because, this rule hasn't gone into effect. We don't know how USCIS is going to roll it out. And what we can do is kind of provide you with some statistics. So for example, an affirmative asylum office application is usually granted about 28% of the time nationwide. However, because USCIS is increasing the amount of asylum officers that are going to be adjudicating asylum claims generally, that number could go up or down. The last I heard, they hired about 800 asylum officers and they opened up a new immigration court in areas to basically combat the backlog in asylum. So after this new proposed rule goes into effect, you could see your interview timeline move up at the local asylum office, or it could be pushed back. We can't predict that right now because it's still a proposed rule, and you can basically still make comments on this proposed rules. Now, the proposed rule was effective 60 days after publication in the Federal Register. It was published in the Federal Register on March 22nd, 2022. So you can still go and submit a public comment about this proposed rule, and you should submit this comment on or before May 21st, 2022. And then the new final version of the rule will be issued based on the public's comment. Last I checked, there was about 14 comments already up on that. If you need a link to the comment page, let your case manager know or let me know directly and I can email you the link. I'm reticent to provide links through Facebook Live because you would have to go back and www and type it all out and it might be a little bit complicated. It's also, bear in mind that these rules will not go into effect until May 31st, 2022. And even if the new rules go into effect, there might be a lot of new court challenges against the rule, which would delay the implementation of the rollout even further. Most of the times, if some rule works negatively against a client and they have standing in court, they can probably sue, and they'll just kind of put the rule on pause and then wait to see what the litigation happens, what the outcome of that litigation is, to implement it further. It's also worth noting that we operate on the assumption that our lawyers know our court dates, whether they've been pushed up or pushed back because of the new courts opening, specifically we have one opening in Hyattsville. That's not always the case. The trend that I have noticed is some attorneys haven't been getting the notices. So as a best practice, anytime you have a court hearing, whether it's a master calendar hearing, and the master calendar hearing is just where you go and schedule your individual hearing, which is the hearing on your merits. And you also tell the court what form of relief you want. Or if it's an individual hearing, which is a hearing on the merits, you should always check the EOIR automated case information portal and see what they say is your next hearing, whether it's master calendar or it's a individual hearing. You can do a keyword search on any browser. It would be called the EOIR Automated Case Information, and then it'll direct you to the Department of Justice page. If you can't find that, you can always, again, email me or your case manager, and I can provide you the link. And you would just type in your A number, and all of the court information based on your A number will pop up for you. And on a very final note, and this is the most important, right now we're seeing a lot of asylum cases, individual hearings being pushed up in immigration court. So it's very pertinent that if your client comes to you and they do not have legal representation and the court hearing is coming up soon, that you contact your case manager at Asylum Works, or you contact me, the program manager for legal outreach, and let us know that you need a attorney as soon as possible. Of course, if you're in the District of Columbia, we're happy to refer you to Alight. They are our partner there, and they can provide some low cost or low bono services if you are an Asylum Works client and are DC resident. And I think that wraps it up for me. I didn't know if you have anything else you wanted to add, Lindsay?
Sure. Yeah, just to sort of, summarize for everyone once again, the rule, this new rule to make the asylum application much faster is only applicable to certain people. And those are the folks who are seeking asylum through the expedited removal, or through their expedited removal process, which is partly based with a credible fear interview. And although that new rule doesn't have new procedures for our typical asylum seekers that we see, the affirmative asylum seekers are people who are already here or who are referred to the immigration court. We do expect that the implementation of this rule could have an effect on everyone's case, maybe for the better, maybe for the worse. And thankfully, Congress has approved funding for hundreds of new asylum officers, since asylum officers are going to be bearing the brunt of the processing for this new rule. We are supposed to have hundreds of new asylum officers, but also how the asylum office will separate their officers to adjudicate either affirmative processing or these new cases coming in based on this new rule is yet to be seen. So we may see a delay, or because of a huge influx of new officers, maybe we'll see things speed up. It's really hard to know. And like you said, with the immigration courts, new courts are opening across the country. We've had a new immigration court open in Hyattsville, Maryland, in just the last several weeks. We have another one opening in Virginia. So you're going to see cases shifting, some jumping forward by years, some just dropping off the calendar and not having a date for a while. So again, even though the judges are going to have to focus on certain cases because of this new rule, we are getting a lot of new judges and new courts. So I really hope that we'll see sort of a balance of not all resources going to manage the cases that are being prioritized under this new rule. And hopefully our asylum seekers will in general see some benefits. But like you said, once the rule goes into effect, there will likely be litigation. Who knows when it will be fully in effect, if a judge will stop it, if it'll go forward. So there's still a lot left for us to see. And of course, we'll try to keep you updated as changes are made, depending on what goes into effect when it's stalled. It's sort of a reminder of what it was like under the Trump administration when there were so many changes and so many things to update everyone on. And then as soon as we updated you, a court would make a decision, and then it would be back to the old rules. So we'll try to keep you posted. If you have questions, feel free to drop them in the comments. Of course, this is a public forum, so don't ask anything that would be private. If it's a general question about the process or how this may affect your case, please feel free to send us a comment or question. And then, of course, for the Asylum Works clients in particular, you have your case managers, and you're able to reach out to them. And for our clients, obviously, they have our attention 24/7. So, all right, everyone. So I don't see any comments or questions for now, Parisa. So I think we can wrap up. And then as questions come in, we can certainly respond as soon as we can to those questions. So.
Absolutely. And I will also share this recorded section onto our own Asylum Works page. So if you drop any questions there, again, what Lindsay emphasized, make sure you're not providing identifying information in the comments. Probably better if you just message us in private if it's a case-specific question you think it'll impact you. And as always, we are working with a government bureaucracy, so there could be ups and downs. But I think all of these proposed rules are kind of hopeful in a way that they're trying to mitigate the bad backlog. Now, whether this does exasperate it or not is not something we can predict until the proposed rule is officially implemented.
Absolutely. All right. Well, thank you for joining tonight. And we will be back next Tuesday with a new topic, new information. If anyone has questions or a topic they would like for us to cover, please do so. You can send that to us as a comment or a private message or an email. we'd be happy to try to cover topics that are of most interest to our viewers. So thanks, everyone. Thank you, Parisa.
Thank you, Lindsay. Everybody have a great night.
Bye.